Hello and good afternoon, ladies and gentlemen. Thank you all very much for tuning in for our autumn insurance law webinar series. This is part of a regular insurance law series presented by Kelly Santini. Our presenter today is Mitch Kitagawa. Mitch has been a partner in the insurance law group at Kelly Santini since 2006. His practice is focused on property, personal injury, casualty, and professional negligence matters, as well as subrogated claims. Mitch has been practicing in insurance defense for 15 years, and it's safe to say in those 15 years he has appeared in hundreds of pre-trials all across Ontario, including Ottawa, Belleville, Kingston, Cornwall, Toronto, Pembroke, Perth, Thunder Bay, I'm sure, to name just a few of the many places Mitch has traveled across our province. We were to have a second presenter today. Unfortunately, Samantha Ituragi, as some of you may know, is pregnant, and her doctors have ordered her to put her feet up for a little bit. And as much as she wanted to be here, she decided she couldn't pass up the opportunity to put her feet up briefly. The insurance law group at Kelly Santini is one of the largest insurance defense groups in Eastern Ontario, and it's also a member of Risk Management Council of Canada, which is a network of independent insurance defense firms with a presence in all the jurisdictions in Canada. And all the members frequently work together on matters requiring legal representation in another province. Just before I turn things over to Mitch, just a couple of quick things to mention. The first is please send us your questions. There should be a dialog box on your screen where you can type in your questions, and we'll reserve some time at the end of the presentation to answer as many questions as we can. Also, during the webinar, we're going to have a few survey questions. These survey questions will pop up on your screen, and you can just use your mouse to provide your multiple choice answer. And finally, at the end of the webinar, you'll have the opportunity to provide your feedback on the presentation. That'll be just as we log off. So to begin, just before I turn things over to Mitch, actually I mentioned the survey questions. Let's actually start with our first survey question to set the tone for the presentation. In your experience, are pre-trials worthwhile? If everybody could just take a moment to provide their answer to that. Thank you very much. I see answers are coming in already. We'll give you everyone just a few more seconds. And we're just about there with everybody having cast their vote. Okay, I think everybody's answered in, and the results are fairly overwhelming, and I'll share those results with you now, which is 96% overwhelmingly saying yes, pre-trials are worthwhile.
Wow, that's great. It tells me that people are making use of them as probably they should be. I'd love to talk to the 4% who say no, because I want to find out what it is that they feel isn't working for them. But that's great. It's a great start to talk about these, because hopefully we can make them a little more worthwhile for you. So. As you can tell, the voice has changed. This is Mitch. You have to picture us. We're in Samantha's office, and we've got a laptop in front of us and a mic. And of course, because it's Halloween, Keith Gallup, who gave the introduction, he's wearing his Batman costume, and I'm wearing a tutu. All right. So the plan for our talk today is to, as you can see, we'll start with talking a little bit about what a pre-trial conference is, and then getting ready for it. We'll talk about the PreTrial Brief, which is important, of course, but that's something that the lawyers typically take care of, but there's just a couple of things for you to look at. We'll talk about strategic planning for the pretrial, attending the pretrial, and then steps to take after the pretrial, and then you can hit me with your best questions. So the introduction. I wanted to just explain that the webinar is meant to speak to you as a representative of an insurer. So I'm not going to cite a lot of case law rules. Really, that's what your lawyer is supposed to do and supposed to know. That's what we as lawyers bring to your file. This webinar is meant to be a bit more informal and certainly practical. Many of you may know that fewer than 5% of cases go to trial. This came from Justice Baudouin. But I suspect that it's actually a lot less. What some of you may not know is that that's unique to Ontario. Other jurisdictions aren't so focused on pretrial settlements. They're focused on getting cases to a trial, believe it or not. One of the advantages or one of the characteristics of a pretrial is that it's the only time a neutral third party looks at your case, and so you should take full advantage of that. It's the last best formalized chance to settle. You may have other chances, but they come after trial preparation is done. So a lot more money has been put into the file. I think that was why the opening slide had a wad of bills on it to show how much money you can spend on a case. It's certainly not the amount I'm getting paid for the webinar. And finally, you know, by way of an introduction, think about pretrials as you know, all the parties being in the room together. So there's no better time to settle or to try and get at least something done if you can't settle it. So let's talk a little bit about a pretrial conference. I see because most or all of you may have been to one already, I'm going to talk sort of first of all formally about a pretrial conference, and then after that I'll talk a little more practically speaking. Of course, the pretrial takes place typically after mediation in this jurisdiction, that is in Ottawa. You would have a court compulsory mediation. The mediator sends in his report that things haven't settled, and then you have to file a form, or at least typically plaintiff's counsel files a form that will have dates on it that they had already canvassed with the other lawyers. So they provide a list of dates and then send the form in, and the court picks the date for the mediation, or sorry, for the pretrial. And of course, 10 days before the pretrial conference or settlement conference, a brief must be presented to the court. As you know, the pretrial conference is a formal step in litigation, in which the parties attend before a judge, and in Ottawa it's before a master sometimes, to present their case in a summarized fashion. And the idea is that the judge or the master hears your submissions, and then they provide you with their view of the case. They'll provide you maybe with some strengths or weaknesses or what they think would happen at a trial. Then they suggest how best to settle the case, and if you still can't settle, then a timetable is created to get you to trial. That's what's supposed to happen, but as I said, I intend to be a little more practical and speak about what does happen and why, and in some instances how to deal with it. And I'll give you some examples of some odd pretrials that I had. Once I was in a smaller town. We went to the judge. I came from. Obviously I drove from Ottawa to the smaller center. We went in front of the judge. We gave him our pitch, and the judge looked at us and said, "Well, you guys have a tough case," and that was it. And then he asked me what my route was to go home. So sometimes they can be of great assistance, and sometimes not that much assistance. So while it's the only chance before a trial to hear how a neutral third party will hear your case, and of course that's different from a mediation. In a mediation, the mediator tries to get you to speak to each other, or at least will sort of conduct some shuttle diplomacy. It can also be a chance for you to send a message to the other side. It gives you a chance to test some theories that you may not actually use at trial. You just want to see if you'll get any traction when you float the idea up before a judge. And you can also get some orders that you're seeking without resorting to emotion. And we'll talk about that a little bit more. Keep in mind that pretrials can be heard either in the judge's chambers, or I did one, typically in some places we'll do them in a small reading room, or they can actually be heard in the courtroom. It'll depend on the facility that you're at, of course. I know I can tell you about one where I had, it was a Friday afternoon. Again, I was in a smaller center, and I won't tell you where, so we won't guess. And I was sitting in, it was Friday afternoon, I was sitting in the courtroom. The judge walks in. He's wearing a golf shirt, a pair of cotton pants. And he looks over at me and says, "I'll be with you in a second." And he goes into his chambers, into his office. And then the court clerk comes out, and the court officer comes out and gets myself and plaintiff counsel. And we go into his room, and he literally sits back, he puts his feet up on the desk, and he lights up a cigar in a public building, of course, but I guess who's going to give him a ticket? And he turns to me and he looks at me and he says, and I'll paraphrase this, says, "Mitch, you're effed on liability." And he starts laughing, and he turns to the plaintiff lawyer and he says, "Now, what are you going to give him by way of damages?" So you can expect that some of these are rather informal. I'm going to talk a little bit about strategy discussions, and I'm going to preface it with by talking about what it is that we do as lawyers. I can hear your lawyer jokes in your head, or that you're actually saying them right now. But as lawyers, the idea is that we work for you and we work with you. We help you to navigate the court system, but you make the decisions when the time comes to do so. We give you options and recommendations, but you make the decisions. And that's very important because you don't want to lose control of your file. Don't let your lawyer do something with which you disagree. As an insurance defense lawyer, I can tell you that my overall objective is to work with you to close files as quickly and as economically as possible. Now, I mention all of that because it should permeate every decision made in the litigation process. Some of my clients will get tired with me, and sometimes they'll say, Mitch, you just choose. But that's not my job to make decisions. That's your job. My job is to provide you with the options and the recommendations, and then I carry out your instructions. Of course, the same is true for any pretrial hearing. So in preparing, you start by asking, what do you want by way of an outcome? Do you want an assessment of liability and or damages? Do you want more disclosure from the other side, or updated documents, or more examinations? Do you need more expert reports, or do you want to amend your pleadings? So it's not all just about, as insurer, what do I have to pay, or do I have to pay, but you have to think about what you want and then discuss it with your lawyer. So what other kinds of things should you be discussing? Well, one way is to discuss the best and worst outcomes of the pretrial. And that's true strategy. What will you do when the judge says the other side will lose? Will you insist on costs and risk further alienating the other side who just got whacked? Or do you give them a way out by going without costs, or going so far as to offer to pay some disbursements? Now you're going to say, why would we pay anything if the judge just said we're not liable? And that's because there's a certain psychology to pretrials. For those of us working for an insurance company, it's business. We're not personally attached to our files. Litigation to a plaintiff is completely personal. So when they're suddenly told their claim is not worth anything, they're being challenged personally. It's an insult to them after investing likely well over a year of their lives, likely some money into the process. If you're told you'll lose, then doesn't that actually compel you on to a trial as a plaintiff? So trial's the only chance that you have, and it now becomes your last chance. So as an insurance company, you have to consider your business philosophy. Some insurers have shareholders who want the issue ended as cheaply as possible. You can offer to go without costs, or pay some disbursements to show you aren't trying to rub it in their face that a pretrial judge has just told them that they have no liability. To entice the other side to accept this decision is to provide them with what I call a graceful exit. At least they feel like they're getting something. They can accept the judge or master's view of the action and also save some face while doing so. However, there are also insurers who would take the position that costs should be paid. Rarely will the plaintiff agree to this, certainly at the outset. The insurers are taking the position knowing that it may cost them more money to find out if the pretrial judge was correct by taking a tough stand, but they also want to carve out a reputation such that a plaintiff lawyer has to think hard about suing them again. And this scenario may very well work. Unfortunately, you won't know because you won't know what claims were never commenced against you in court. But as I said, it may well work, and I think it's a legitimate manner in which to conduct business because that's the way litigation is set up. But what I want to get back to is your strategy in that regard will depend on the business philosophy of the insurer for which you work. Of course, what is more important is to discuss what the worst case scenario is and how to react to it. So the judge tells you you're liable and you have to pay everything. So start discussing with your lawyer what you think you should do. There's a couple of things you can try to do. You can try and ask the judge if he shuts you out on liability, you can ask him to get some reduction on the damages for trial risks, at least the possibility that you could win. Sometimes you may want to say to the judge, or your counsel may want to say to the judge that you respectfully disagree, but you want some time to go back and reassess your position. And so you can either ask that you adjourn the pretrial and continue at a later date, if the other side is agreeable to, or you can simply end the pretrial at that time, or you can take some time out to go and speak to your lawyer. Perhaps you're prepared to actually pay it because you knew that this was coming. But the idea is to discuss all of these things with your lawyer so that you're not caught flat-footed when those outcomes arise. I want to talk about IMEs and other reports, other expert reports. Now, the current rule is that expert reports must be served on parties 90 days before the pretrial. And of course, most of the time, you won't know exactly when a pretrial is going to be scheduled. And the truth of the matter is that right now, no one really does that. But it is always a gamble to wait until your pretrial, until you get your IME. Judges, as I say, are quite forgiving right now, but they could drop the hammer at any time. So you may want to have at least some explanation as to why you don't have a medical report or an expert report by the time you get to the pretrial. The judges certainly like them. And that a day is coming where someone is going to get burned by this, and a judge will say, you know what, you don't have your expert report. You're supposed to have it 90 days before the pretrial. I'm not going to allow you to file a report before the trial. And then you have to definitely reassess your position at that point. I want to move on to talking about the pretrial brief. Now, a good brief can tell a good story. I was at a pretrial recently in which the judge came in, sat down, looked at us both, turned to the plaintiff and said, "You don't have a very good case." We hadn't given our pitches yet, so all of that was being based on the pretrial brief. Now, pretrial brief should be brief. I'm going to talk a little bit more about that because that's what judges, the way judges feel. But you have to think about this. Judges do this every day, all day, and they want to sort of be able to get in and out of the issue. They don't have a lot of time. Chances are they've read your pretrial brief about 10 minutes before they come into the room. So it's got to be right to the point. But it also has to be fair and accurate, and your counsel should attach the reports that they want to refer to. I always suggest that if you have surveillance, certainly good surveillance, to put it in. So if you can take some still pictures, you can put them, embed them into your brief. There's a question now that you'd have to consider with your counsel about whether or not you want the offers, if they're assuming the offers have been exchanged, whether or not you want to put offers into your pretrial brief. The judges certainly want them in there. They want them in there because it gives them some guidance. But you may not want it in there because you may want to hear what their actual assessment is, a very objective assessment of the claim and of the action. If you're going to put an offer in, do the math so they completely understand the deductibles, any deduction you're taking for trial risk, or any contributory negligence. Some briefs, you'll notice when you look at them, will have law in them. They'll have case law in them. Some won't. The difference is whether or not you have a lawsuit or a fact suit. And sometimes you'll hear Justice Baudouin in Ottawa refer to that. What he means by that is that a fact suit is one where the action will turn on the facts. So picture something like a slip and fall, and the question is, where did the plaintiff fall? So that's a fact suit because you want the court to believe she fell in one place, and the plaintiff may want you to believe that she fell somewhere else. A lawsuit is one in which you may know all the facts, but what you're asking the court to determine is whether or not there may be a duty of care, or if you've lived up to what your standard of care is. So, for instance, taking the slip and fall, if you've maintained the area, the question is now, you know all the facts, but is that considered a reasonable maintenance of the area? So again, you may see, if it's a fact suit, you may not see any case law. If it's a lawsuit, then you may see some case law in your brief. I'm going to move on to talk about a strategic plan for the pretrial. And so I talk about how do you want to play it. And what I'm talking about is, since I've already talked about considering your best and worst scenarios, I'm now referring to how you want the pretrial actually conducted. And your lawyer can have some control over this. The question is typically, do you want an assessment? So that is, the judge will come in, the judge master will come in, and they will tell you their view after you've given them your pitch. Or do you want a mediation, a negotiation session? where they'll send one party out of the room, and then the judge or master will speak to them, and they'll bring you back in, and the other party will leave. Or sometimes you can have a combination of the two. And I have had that when a master conducted a mediation. He would privately tell the parties some of what he thought to try and engender a settlement. And eventually, as we went through each party seeing the master individually, he would tell them by the end of it exactly what he thought of the complete case. So feel free yourself or your lawyer to tell the judge or master how you would like it run. Now, in the course of the pretrial, at some point, you may want to excuse yourself from the room. And you may want to do that for a number of different reasons. You may want to do that so that the judge can speak to the plaintiff or the plaintiff's lawyer directly. And that's sometimes you do that because you know that the plaintiff isn't listening to their own lawyer, or that the lawyer thinks he has a better case than he does. And so the judge can look them in the eye and state exactly what it is they feel about the case without embarrassing them, without them having to put their game face on. Conversely, you may ask the other side if you can have some privacy with the judge. And you may want to do that again to point out to the judge that you think he should be speaking to the plaintiff directly or to the plaintiff's lawyer directly. Or you may do it because you want to float a particular theory out to the judge that the other side may not know about or may not fully understand or comprehend, and you want to see how the judge reacts to it. Or if there's something that troubles you about your case that you don't want to highlight for the other party. However, that part of the strategy may have an effect on the judge's view of the case, and I'm going to explain that a little bit later. If you have an experienced lawyer, he may know the judge to know what to expect. And I have up on the slide, they are human, and they definitely are, and you'll learn the traits of each of them. If you practice in a particular jurisdiction, you'll know what the things that they sort of like, the things they don't like, what they like to talk about, what their view on certain things are. Certain judges will tell you certain stories over and over again, so you can play off of that. And so you learn their way of dealing with the pretrial. You may think that you know who your pretrial judge is going to be, but the truth of the matter is you really never know until they step through the door at the pretrial. In some jurisdictions, they'll give you a list with the names. In other jurisdictions, they won't tell you until you get there, and even when you get there, you'll find out that they've changed it around, because sometimes one judge may finish some duty sooner and will have some time to spare, and he'll agree to hear some pretrials. So again, that goes back to your pretrial brief. He picks up the file a couple of minutes before he actually conducts the pretrial itself. So we're going to take a bit of a break here, and I think we're going to go.
Pardon me. Finger was a bit trigger happy. We'll get that. Mitch, get a sip of water and launch our second survey. Would you rather attend a pretrial by phone or in person? And I'll launch that now, and the question should be up on your screen if you want to take a moment to answer that. Thank you very much. I see votes are coming in. We'll just give it 5 more seconds. Okay, and we'll close the poll now. Thank you very much, everyone, for participating. And we'll share the results with everyone now. Mitch, we have 28% saying they'd rather attend by phone and 72% in person.
Yeah, and I expect a lot of that has to do with certainly convenience. Considering most of you feel that the pretrial is worthwhile, a worthwhile endeavor. But what I always say is, if you really want this matter to settle, you should show up in person. And just because it's not essential, because certainly I've settled quite a few without my client being there, but I would say that you have a greater chance of settling when you attend in person. Of course, you're asking me, don't you always have to attend in person? And if you look at the rules, all the pretrial rules demand that the parties attend, but here again, you have to know the lay of the land. So in Ottawa or Toronto, you would typically have to attend in person or get permission to attend by phone, but you better have a pretty good reason why you can't attend. Now, in some of the smaller jurisdictions, so if you go along the St. Lawrence River, so Belleville, Kingston, Cornwall, and even up if you go up the Ottawa Valley up to Pembroke, what will happen is you'll never likely see the judge, despite the fact that you're supposed to attend. What will happen is the judge will meet with the lawyers first. He wants to sort of get the lay of the land. He wants to hear what the lawyers have to say about their case without the pressure to perform in front of the client. So the judge calls us in so he can speak freely. And if you're wondering exactly what we speak about, of course I can't tell you. That's part of the lawyer code. Now the truth is we do sit down, and it is very informal. And as you can imagine, it's like a group of any professionals. You start by talking about what's in the news or the weather, and then you get around to the case soon enough. But what you're really doing is you're creating some rapport between the individuals so that they can speak frankly to each other at that time. And it allows certainly the judge to speak without having to put on a game face or without having to couch any terms that he wants to use because clients are in the room. Then after you have that conversation, and the reason why I don't bring my clients along, certainly along the river, is because the judge will say, now go tell your clients what I said. So you never get to see the judge. And for the most part, that's why the judges don't get too worked up if the insurer is not there. Now, having said that, you can certainly steer the process a bit. Because again, if you think the other party should hear from the judge directly, your lawyer should say so. And that'll happen when, again, the other lawyer or his or her client is being difficult. But you can direct the judge to do that. As I said, if you really want to settle, come in person because you'll get to meet the other party. And it's an opportunity to discuss the file, and it's just another opportunity to try and settle it again. And of course, the difference between meeting someone in person and trying to do things over the phone is there are so many personal cues that you will get and intonations that you'll hear in their voice that you can use in dealing with trying to get the file settled. So you feel that it's not worth traveling to a specific jurisdiction, then you have to get permission in advance to attend by phone. As I said, it's typically not an issue, but you do have to be ready to participate by phone, and that can mean one of two things. You can attend by phone by actually being on the speakerphone in the hearing room, so you're on the line all the time, or you can just be accessible by phone, which means that you'll be called at a specific point in time. Again, this depends on where the pretrial is being held and what judge you have. If you are attending by phone, be prepared to start early, because oftentimes, once the counsel are in attendance, and if the pretrial before yours is done, the judge wants to get rolling. So expect to start as early as up to 15 minutes. And if you are on a phone and you want to talk to your counsel, make sure that you're alone and you can speak to your counsel privately. Don't just blurt something out, because you may be speaking to everyone in the room, and it may be in a courtroom setting. To prepare, make sure you know your facts, including dates and amounts, and have a calculator with you at the ready. And keep in mind your strategy for the various scenarios. And also when you're on phone, make sure you stay engaged. Don't have other files or be looking through other files at the time. We can hear you on the keyboard, by the way, when you're on your phone, so we can hear that clicking away. And you may be just making notes, but a lot of times people are thinking that in fact you're working on something else. You're not fully engaged. So as I say, your best choice is to attend in person if you can. Now, of course, at pretrials, your attendance is only, and your lawyer's attendance is only part of the equation. A larger part of it is the judge. A few papers have been written, more locally by Justices Ray and Justice Baudouin, but they've had the same themes. Be brief in your brief and your presentation. Explain the facts and then take them to the meat of the issue. Quote the experts. Don't paraphrase, because the judges want to hear exactly what the experts have to say. And provide witness statements. That's also important to the judges. And of course, they want you to know your case, both the file, but they also want to know the litigation. Where are you in the litigation? What offers have gone on? And they want to know if anything's has been agreed to. And of course, they want to know what exactly is at issue. For your part, a judge definitely wants to know that you've arrived with some authority to settle. Now, when we talk about what really motivates a judge, as I said, I may have mentioned this before, that the Ontario courts are skewed towards settlement. And that's because resources are getting thin compared to the population in the province. So when Associate Chief Justice Doug Cunningham retired, he said in his speech that resources are extremely stretched. He was worried about judges becoming burned out. So that leads us to ask the question, well, what motivates judges? And for some of them, it's to get a settlement at any cost. What I mean by that is that they'll oftentimes give little consideration to liability because they don't want to have a long trial scheduled in their courts, and they actually don't want a trial at all. So some may say whatever they have to say in order to get a settlement. And by way of an example, I had a case in which we had a plaintiff, and we suggested there was some contributory negligence, so the judge said, sure, you split it 50-50. And then I said, well, what about liability as between the two defendants? And the judge said again, sure, split it 50-50. So the judge was just trying to blow through liability to get onto damages because that's where the matter settled. So I certainly didn't feel that we were getting a proper assessment on liability. So they split them, and they want to sort of crack open the policy to get a settlement. Remember when I said that asking judges about the weakness of your case or concern that you have? Well, whether the judge believes that it's a weakness or not, he or she may use it against you again in order to get through liability or to increase damages again. They just use it against you in order to put you on some uncertain ground, not because they really have a particular view of that theory. And what they're doing is exploiting your concerns about your case, again, to get you to settle. So even when I said it gives you a neutral third party to review your case, there may be times when you wonder about the validity of the assessment. Incidentally, there's a firm in Toronto, I think it's in Toronto, somewhere in southern Ontario. They're trying to put together pretrial assessments and then trial outcomes to see if there's any sort of a relationship. And I expect to get a copy of that at some point.
All right, time for Mitch to have another drink and move on to our survey question number 3. Do you let your lawyer know the maximum you're willing to pay to settle a file before the pre-trial? And I will launch that question for you. Should be appearing on your screen now if you want to take a moment to give us your answers. Okay, thank you very much to everybody who's participating. The results are coming in. We're at 82%. We'll just give you a few more seconds. Okay, I think we've got the results in. We have 33% saying yes, and we'll share that with you now. 13% saying no, 46% sometimes, and 7% saying yes, but not the real amount. So, Mitch?
I think the 7% are very truthful. I like that. And I like 46%. I'm taking that as a positive. It means you trust us some of the time, so that's good. But of the 13% who say no, you know what, I totally understand that, and I totally get that. The reserves are obviously jealously guarded for good reason. I want to talk about the executing the strategy. So you know, once you're all in the pre-trial, you're ready to go. It's important to listen to see how things are flowing, and then react to it. So at that point, you know, once you get a feel for what's happening, then you ask yourself, do you want to get out of the room and leave the plaintiff with the judge, or do you want to be alone with the judge? But don't move too fast, because you don't want the other side to see that what you're doing is contrived. The same is true when you're negotiating. It's good to have a first offer ready, but after that, don't respond too quickly, or the other side will figure out that you're eager to settle, or at least they may think that you're eager to settle, and they may continue to bargain when you've said, no, you know, this is my last offer. Sometimes you want to make it look like a struggle to let the other side know that you don't completely buy their case. And the next point relates to the question that Keith had asked. Have you instructed your counsel to offer a number or two at his own discretion? And so I know that sometimes you don't tell counsel what your reserve is, and as I said, that's fine. There'll be times when you'll be in the room with everyone and you'll be asked to put out a settlement number, and if your counsel doesn't know because they haven't been given any instructions, they may look at you along with everyone else to see if you're going to increase your offer or make an offer. So again, just be prepared to have to make that call if your lawyer doesn't have instructions. you may again want to take a break and just step outside and speak to your lawyer if you're indecisive about that, but feel free to make the call. And consider always having a contingency position if things go wrong. And as I say, the sort of bottom line contingency position is always a call a timeout. Just say, can I go and talk to my lawyer for a second? And the two of you can step out of the room. But one of the things I want to encourage you, for those of you who are either on phone or in person, is to feel free to interact with the judge. Speak to the judge. The judges like it. They want to know what you're hearing. They like to hear what you have to say without the filter of their lawyers. And sometimes they'll certainly invite it. Sometimes they'll look at you and make comments towards you. So expect that will happen. One other thing that sometimes you'll see are some excitable lawyers on the other side, someone who gets overly agitated or dramatic. Judges do not like that. They don't like it at all. So what should you do? Well, as I've said, keep calm and carry on. The more dramatic the other side gets, the more calm and measured you should be. The court will greatly appreciate it, and since you'll likely see the judge or master again, it will also be remembered. I'm going to talk a little bit about technology. It's interesting that judges are now saying to bring in your video with you. When one of the first times I had surveillance, the judge was clearly uncomfortable with it, wouldn't allow me to show it to him in the pretrial. Now it's a lot different. As I said, consider encouraging your counsel to take still pictures, snapshots, and embed them in the brief if it's possible. And that will spark the judge's imagination as to what else a person can do. I've used it quite effectively in a number of different briefs. It's even better if you can take a quote from the transcript about something the person says that they can't do. So those are the transcripts from the examination for discovery. And then you put a picture right below it of them doing the exact thing that they said that they couldn't do. As I say, it's very effective. The judges like it. And if you've got the video there, a judge may even stop to watch it for a little bit. So it's well worth doing.
And now, just with a few minutes left to go, we'll just have our last survey question. If you have attended a pretrial, did you think the judge or master's assessment was reliable? And we'll launch that survey question for you now. Okay, thank you, everyone. We'll give it a few more seconds. We're just about at full voting. Okay, I'll close the poll now. 35% say yes most of the time, 63%, 3% only some of the time, and 2% not very often.
Well, that's really interesting. You know, insurers use the court system, of course, more than any other industry, and you know, one of the things I marvel at, and I've heard lawyers say this to judges, they've said to them, you know, there's a reason why insurers want jury notices on their files, and it's because they don't have a lot of faith in the way the judges view certainly liability and sometimes damages a lot of the time. So I think that's in keeping with sort of what I've been hearing. Well, to wrap this up, so you finished your pretrial. Obviously, you haven't settled because you've been given a trial date. So what do you do next? You can send an offer to reflect what was said, or you may want to reinforce your own position and send an offer that reflects that, and just showing that you don't agree with what the judge's or master's view may have been. But it's probably the perfect time to send the offer because people are now looking at their files and saying, okay, I've got to start getting ready for trial here. So I'm going to send an offer over to the other side to make them think about how far they want to take this. Also, if you have to amend your pleading. So if at the pretrial the judge said something to alert you to a new claim or a new fact, then you may want to amend your pleadings at this point in time. And it's also a good time to reassess your position, taking into account what the judge or master's opinion was. At this time, you also want to look at, do you need further documents? Do you need updated productions or other documents? Do you need more expert reports? Do you need further examinations for discovery? If you do, those are the types of orders that you should get at your pretrial. But if you don't have the order and you want to get an expert report, then you better get on it right away. And it better be a responding report. That's the best way to try and get it in. If you're just trying to get your first report, you may have a little bit of difficulty getting it in. But again, for the most part, judges have been pretty forgiving so far. So as I say, once you've finished the pretrial, it's a good time to sit back, reflect on what you have, reflect on what the judge told you, look at what the other side's position was in the course of the pretrial, reassess your case, and decide if you want to either bolster any weaknesses if you can, or continue to strengthen the areas where you think you're already strong. But you're on your way to a trial at this point, so it's time to get ready.
Thank you, Mitch. We'll now, we have about 4 minutes left and happily take your questions. If you do have a question you'd like to pose to Mitch, please just type them in on the dialog box that is on your screen. Mitch, if the case does move on to trial, does it automatically have the same judge that heard the pretrial?
No, in fact, it cannot have the same judge because, of course, then the trial judge is prejudiced. So if you have a particular judge that you don't want to see at trial, then you're happy when you see them at pretrial, although you can't judge shop in this, certainly in Ontario, it's very difficult to do so.
Okay. And how long does a typical pretrial last?
Well,
how long do people need to be on the phone?
Yeah, well, of course, it depends in every case. I've had them go for longer than a day. I've had them go for an hour. It depends on how difficult they are. If it's a simple, slip and fall, sort of run-of-the-mill rear ender, that sort of thing, you're probably looking at an hour. If you have a large case with a large number of parties, as I say, sometimes we've had them where the court has assigned a judge to you for a day or a half a day, and all the parties get together and try and resolve it. But typically, for a simple case, think about an hour.
Okay. Another question has come in. Are there ever any penalties for coming to the pretrial without authority, for potentially wasting time, etc.?
That is a great question, and I'll tell you why it's a great question. There is a particular judge, whose name I won't mention, who has gone so far as to assess costs against lawyers personally for not showing up with a pretrial brief. So you can imagine if you show up and you don't have authority to settle, there may be repercussions. Only in extreme cases will that occur penalty-wise, and it depends on who does it. If a plaintiff shows up, a judge may, and they don't have authority to settle, a judge may say, well, then I'm not going to assign you a trial, and you'll have to come back for another pretrial. So there are different, so there are different sanctions they can do. If, as a defense lawyer, you show up and you don't have authority to settle, I can imagine that a judge would be quite upset. Can again order costs and order another pretrial. Could order costs and say, and if you're looking for you want another expert report or some order from me, forget it, because you've just wasted everyone's time. But the vast majority of times, a judge will frown on it, but not necessarily impose any sanctions.
Okay. I think we have time for 2 more questions. Mitch, first one, if the judge refuses to let the adjuster into the courtroom, can we ask the judge to reconsider?
Yeah, actually, another good question, because I've had cases where I've gone and we've sat down, and I said to the judge, I said, you know what, my client has come from Ottawa with me and traveled just as far, and he'd really like to hear what you have to say. Do you mind letting him in? And I have yet to have a judge say no to that. So, if the judge has something he wants to say right up front, they may say it before the client comes in, but I've never had a judge say no to that. So typically you can have a judge, you can have the adjuster come into the courtroom, and you're saying, can we ask the judge to reconsider? I'm not sure if you mean reconsider the case if you're there, reconsider you coming in. But there's, I don't know of a judge who would say no to a client coming in. That's really what they're supposed to be there for. In any event, at some point they're supposed to make contact with the parties if they can't settle it.
Okay. And finally, let's ask, we'll finish on the age-old money question. Will it assist the lawyer if the adjuster lets the lawyer know what his or her settlement figure is?
Yeah, absolutely, because it fits in well with the lawyer will, certainly, I'll put it this way, most lawyers are able to make, will make adjustments as they go along. They'll see the way the pretrial is flowing, and so they'll make an offer that they think will get the matter settled. As I say, we want to settle as economically as possible. So if I know what your bottom line is, but I think I can make an offer that will sound credible at less than what your bottom line is, then I'm certainly going to make it. Maybe make a strong stand on it, and then maybe after only some great cajoling will I go up somewhat. So it is of great assistance to know what your bottom line is.
It's now 1 o'clock, and we've come to the conclusion of today's webinar. So thank you all very much for participating. If you did send in a question or do have another question, by all means, feel free to email Mitch or myself. If you have typed in a question, we will be sure to come back to you. And if you'd like a copy of the slides, again, please email Mitch or myself, and we'll happily Mitch has sent it to him. His email address is there for you all to see on the screen. And Mitch will happily send you off a copy of the slides. A recording of this webinar will be available in a couple of days if you have colleagues who'd like to see it. Kelly Santini has a YouTube channel, Kelly Santini Law, where this recording will be, along with probably 4 or 5 other insurance law webinars that we presented over the last couple of years. And we will be back in the new year. We have 2 or 3 lined up for winter and spring 2013, and we'll be sure to pass on details of those in the next couple of weeks. So thank you all again for participating. As I mentioned right at the start, just as we sign off on this webinar, you'll have the chance to provide your feedback, which we would greatly appreciate. Your feedback on today's presentation, and with that, any suggestions you have for topics you would like to see covered in the future. Thank you all once again. Have a great day.
Thank you.